Of the Zoning Board of Appeals of the City of Evanston. The zoning ordinance empowers this board to hear references from the City Council, applications for variances and special uses, and appeals from the decisions of the zoning administrator. Depending on the type of matter, we will either make a final determination or send a recommendation to the City Council. Present here with me tonight are board members Mary Beth Burns, Scott Gingold, Beth McLennan, Clara Weinberg, and Andrew Gallimore. I'm Lori Summers, the current chair. We therefore have a quorum. Also present here tonight from city staff is Melissa Klotz and Dennis Marino. This is a formal hearing, and we will have rules that govern our proceedings. Our most important rule is that only one person may speak at a time without interruption. It's not just civility, but it is necessary to accurately record our proceedings. Anyone who wishes to address the board regarding any matter on the agenda will have an opportunity to do so at the appropriate time. Our normal procedure is that we hear first from the staff on the documents in the file. We will then receive testimony and other evidence from the applicant or appellant. After the applicant or appellant has completed their initial submission, any person who has a legal interest in real property located within 500 feet of the property that is the subject of the application or appeal may then present evidence, reasonably question witnesses, or seek a continuance of the hearing. Next, others who wish to make a statement regarding the matter may do so at that time. When all opposing testimony and other statements have been received, the applicant or appellant will be given an opportunity for a rebuttal or a closing statement. Board members may ask questions of anyone offering testimony or statements at any time. All testimony and statements will be under oath. Although we do not apply the strict rules of evidence, we ask that you limit your testimony or statement to your own personal knowledge. When you testify or make a statement, please tell us your name and your address, and please print it on the pad provided if you did not sign up outside. Because we do not have a court reporter, it is imperative that you speak at a microphone so that your testimony and statement can be recorded. We do have audio and video recording in this room. When all of the testimony, other evidence, and statements have been received, we will close the record and begin our deliberations. And we have 3 matters on the agenda tonight. Because we did not have a quorum at our last meeting, we were not able to officially address the request for continuation for 2627 Lincolnwood Avenue. And I believe that request is to go to the March 20th meeting. So is there any discussion or comments or motions on that matter?
Sure. I guess I'll move that in matter ZBA 12ZMJV-0008, that the applicant's request for continuance to March 20th be granted.
Second.
It's been moved and seconded. All those in favor, please say aye.
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 The motion is unanimously carried. So 2627 Lincolnwood Avenue will be heard on our, I believe it is our regular scheduled meeting of March 20th. And stepping backwards here, we have minutes that also did not get approved from our last meeting. And were there any comments from the board regarding the draft minutes for the meeting of February 21st? I know, just for clarification, on the agenda it says February 7th, but in my packet I have February 21st. That's right. That's right. That's the correct thing. Okay. So just for clarification, the agenda does say February 7th, but the minutes that we are looking at this point are February 21st.
Hey, Lori.
Yes.
I think February 21st was the meeting we didn't have a quorum at, so it is actually the minutes from the February 7th meeting.
Okay, thank you. So the meeting minutes should actually say February 7th then. So that would be a correction to those. Thanks, Scott. Were there any other comments on the minutes that were provided? Seeing none, I just had one clarification on page 3 of 5, and it's not necessarily so much in terms of the, I'm not quite sure the specific wording of the clarification, but basically, in the third paragraph from the bottom regarding stairs, I think I was questioning. It seemed to me that a stoop was a stair, and I was sort of questioning whether or not that. It seemed to me like a stoop was a stair. Not, I don't know if it was ever stated that it wasn't, but that would just be my only clarification. If there are no other comments on the draft minutes, is there a motion for approval of the minutes?
I move that we approve the minutes. Oh, shoot, what was the date again?
February 7th.
Of February 7th.
I would second that motion.
And would you both accept the clarification of as amended?
Sorry. Yes, with this stated clarification.
Yes, with the clarifications.
Thank you. It's been moved and seconded. All those in favor, please say aye.
Aye.
Aye. That was unanimously carried through, and all board members currently present were also present at that meeting. So moving on to our first actual matter of business, we have 2658 Central Park Avenue. I believe I see Mr. Vennemore in the audience. And so first we are going to read that case into the record.
Andrew Vennemore, agent for Jim Ford, property owner, applies for major zoning relief to construct a detached garage accessory structure. The applicant requests a building lot coverage of 43.9%, where a maximum 30% is allowed, zoning code section 6827, and an impervious surface coverage of 55.6%, where a maximum 45% is allowed, zoning code section 68210. The Zoning Board of Appeals is the determining body for this case. The following documents are placed on file with the application and submitted into the record. Variance application submitted January 17th, 2012. Standards form, zoning analysis, plat of survey dated September 12th, 2011, proposed site plan, elevations, image of property, aerial view of property, and Spark meeting minutes from February 8th, 2012.
Okay, at this time, could I swear in everyone who would wish to speak to us at all on the matter of 2658 Central Park Avenue? If you could raise your right hands, please. Do you swear or affirm to tell the truth throughout the course of these proceedings?
I do.
Thank you very much.
Thank
and
you.
Again, if I could remind you to state your full name and address before you speak.
Sure. My name is Andrew Vennemore, Venamore, 667 Carriage Way, Deerfield, Illinois.
Thank you. Go ahead.
Good evening, ladies and gentlemen. Thank you for your time this evening. We are here, myself and the owner, Jim Ford, are here this evening, as Melissa mentioned, to request relief for the construction of a detached garage at the rear of the property. As you can see from the information that we provided, the existing garage is already located at the rear of the property as it currently stands. However, the reason the owner decided to come and replace his garage is that basically the existing structure that's there now is essentially ready to fall over. It's in a very dilapidated condition. So that's what drove him to entertain replacing that structure. Unfortunately, the existing coverages on the lot at the moment, both the building lot coverage and the impervious surface, already exceed the minimum requirements for the lot, or rather the maximum requirements for the lot in this zoning district. And any replacement structure, unless it was of an identical size to the structure that's there now, would require us to appear before the board. As you can see by the size of the existing structure, it's only 18 approximately 18 foot 4 in depth and about 12 foot 3 in width. Mr. Ford wasn't 100% sure as to when that structure was built, but obviously at a time when vehicles were probably considerably smaller than what they are now. A standard garage in depth, certainly that is constructed even now, is 20 feet. That's typically what's done in the city of Chicago. As we get out into the surrounding suburbs, they can increase up to about 22 feet in depth, but certainly 20 feet is really a minimum. Most vehicles now are in the 16 to 17 foot length range, so having an extra foot and a half in front and behind is really quite minimal. So we've designed, or we're proposing a structure that is minimal depth at 20 feet and is a little bit larger than what's on the property now. We're increasing that to 14 feet. To give enough room for the car doors to open while the vehicle is actually inside the structure. So understanding what the ordinance requires in that it would allow us to replace a structure without necessity or without us having to appear before the Zoning Board of Appeals. We briefly looked at that, but that square footage at only about 225 square feet, if we were to provide that and just do a minimum depth of 20 feet, that makes the width of the garage almost down at 11 feet. So it makes it pretty difficult to provide a practical structure there. So our goal is to replace that single-car garage. We kept it as a single-car garage, obviously not wanting to increase the extent of the nonconformities that we're asking for beyond what we feel is reasonable. And we certainly hope the board agrees with that. If there are any questions of me or Mr. Ford, we'd be happy to entertain those.
I know that the requirements for drawings in terms of garages are somewhat minimal and sometimes typical, so I just wanted to confirm, am I understanding correctly that the implication is to replace the garage with another garage that is hip-roofed?
Correct.
Correct.
Yeah, the existing is hip as well, Chair.
Yeah, that's what I was implying.
Does the proposal, I should have music wherever I talk. Does the proposal include any measures to counteract the effects of the increased impervious surface?
We would, that item came up during the discussion at the Spark meeting. The proposal at the moment is simply to maintain that same drainage pattern, which is the runoff from the roof is basically just going to be running down into the grass that's adjacent. Our thought, as we went through the design phase, was that based on the fact that this isn't a significant structure because it's only one car, that there was ample grass in that rear yard to accommodate the additional runoff. So at this point, we certainly haven't included anything beyond just the standard kind of runoff that will, run off the roof and onto the ground.
Have you determined then where the downspouts will be for this to comply, to keep that water on the property?
To that, maybe I didn't. I'm sorry, I didn't explain well enough. The structure at the moment, as proposed, the water is just shedding off.
Oh, there's no gutters.
That is correct. It's going to shed off on four sides. And so as far as, we're not really going to create a concentrated flow that we would with downspouts. So the thought had been that, I'm adding approximately 55 square feet of additional impervious area with the with the structure, and there are currently no significant drainage issues in that vicinity, and just the thought process that we had with the homeowner was the additional square footage would still shed into that rear yard where it's grassed, where we shouldn't really see any additional issues.
Are there any questions from the board for Mr. Vennemore at this time? Is there anyone else in the audience who would wish to speak to us regarding the matter of 2658 Central Park? Seeing none, are there any other, one last check for questions or any follow-up that you might have? Okay, then thank you very much. We will close our record and begin our deliberations. The zoning board is the determining body on this case. Is there any discussion, comments, consensus?
I'd just say that it seems to me that the existing garage is too small to be functional in today's world, and that the proposal doesn't seem to be very much more than what's minimally required to make it a usable space. So in that respect, it seems fairly reasonable to me. And I'd also note that there aren't any letters or notes or witnesses here tonight objecting to it from neighbors. So I'm inclined to grant the relief.
Yeah, I would agree with you, noting that it is sort of a minimal uptick to current ratios, as well as also noting the fact in particular that the applicant has not sought to make it a two-car garage, and is keeping as much of that yard open as possible. If there's no further discussion, then is there a motion?
I'll make a motion. I move in the matter ZBA 12ZMJV-0007 that we grant the major variation requested, subject to development of the property in conformance with the documents submitted on the record and the testimony.
Second.
It's been moved and seconded. All those in favor, please say aye.
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 The motion is carried unanimously, so good luck with your project.
Thank you very much. Thank you very much.
Next item on our agenda this evening is 1704 Gray Avenue.
Curtis Webley appeals the zoning administrator's decision to grant zoning relief, case number 11ZMNV0084, from section 6467D1 of the zoning ordinance that states any replacement of a legal nonconforming fence shall neither increase the degree of nonconformity nor create any new noncompliance. The applicant was granted relief to relocate a 4-foot-high wood picket front yard fence approximately 3 feet westward to be placed on the west property line. The Zoning Board of Appeals is the determining body for this case.
And are you Mr. Webley? Yes, I am. If you could please come forward then, I'm going to swear you in at this time. Sir, do you swear or affirm to tell the truth throughout the course of these proceedings?
Yes, I do.
Thank you very much. And could you please explain to us why you're here this evening?
Ladies and gentlemen, good night. I'm Curtis Welbley. I live at 2113 Church. That's beside 1704 Gray Street. I purchased that property November 1989, and my neighbor and I had a very a cordial relationship until he sold in 2005. Between the properties, there is a common walkway. When I purchased, the walkway separated two lawns, mine and my neighbor's. We have not added or subtracted from the lawns. My neighbor went ahead and erected a picket fence from his garage to almost midway between his property. He enclosed most of his properties and excluded the walkway, which is a common area walkway. So from 1989, we both have been using the common area walkway. After my neighbor fenced in his property, I went ahead on my side of the property and erected a picket fence as well. In fact, I'm not a very handy person, and my neighbor also helped. So I have been using my properties openly and notoriously for over 22 years. When he sold his property, the new neighbor did not have a problem with my picket fence. Last year, here comes Lieberman, who claimed I'm encroaching on his property. He went ahead, demolished my picket fence, and I was irate. I called the city, I called the cops. Eventually, they replaced it with a non-conforming fence. What I mean is, my fence is white. The neighbor's fence was red. And because his workers broke my fence, he had no choice but to replace some of the staves or the pane with red paints. Now he is saying I'm encroaching on his property, and I'm saying my neighbor gave me permission from day one. We have coexisted over the years openly and notoriously. We maintained a very cordial relationship, and he gave me documentary evidence that he did indeed give me the right to use the property. So I'm asking you to please look at the documentation, take your time, and make an astute decision that will be beneficial to both me and my neighbor. I have a copy of the fence and the border between, if you would like to see it.
You had some other exhibits that we don't have that you wanted to share?
I believe you have everything except these two.
Images? Yeah, I don't recall seeing those. Okay, so I'm going to label these appellants A and B. One A will be of the fence, sort of straight on, and B is looking looking from the side yards to the north towards Church. No, I'm going to get this backwards. To the south towards Church Street. Correct.
Right.
Okay. And sorry, it gets a little bit confusing with all the fences, but did you take these 2 pictures, sir?
Yes.
And approximately when do you think you took those pictures?
This is probably 3-4 months ago.
Okay. And to the best of your knowledge, these accurately reflect the actual conditions on the
Yes.
site at that time? Okay. So could you maybe describe, looking at the picture of the fence straight on here, what are we looking at here? Could you describe that to us briefly?
Lieberman said his ownership extends 3 feet over the fence.
Okay.
So he wants me to move the fence 3 feet westward. And I'm saying,
Because this is your fence
yes,
that you built, but you built it on, technically speaking, over the property line because that was the agreement that you had with your neighbor.
exactly.
Okay.
So is that picture looking west?
This picture is looking east, right?
It can't be, because I thought Mr. Webley said this fence was on the east side of the
No,
sidewalk.
his fence is on the west.
East.
No,
I think you want it on the east.
He wants it west.
Right.
Mr. Webley lives on the west side of the two. He lives on the western property of the
Right.
2 properties.
Right, but the existing location is on the east side.
No, the existing location is on the west side of the sidewalk.
No, it's on the east side. It's on the east side, right?
No,
No, the
it's on the
existing-
west side of the sidewalk.
Correct.
Sidewalk.
This is
on the
east,
west.
so it's on the west side of the sidewalk. Because the sidewalk isn't right here, it's right here.
Ah,
Okay. Okay. So, and just to note, Mr. Cox, the city attorney's here, and now I understand why he's here. Sorry I missed you earlier. Okay, so that's appellant's A. So we're gonna send this on around, and B is again the side yard looking south towards Church Street, and I believe we're seeing the fence that you erected along the west side of
Right.
the walkway that you were sharing.
Exactly.
Okay. So I'm going to send that around as well. And I need to take 2 steps back and understand how this becomes a zoning issue. Because I think I get the issue from the whole legal property standpoint, more or less, at this point, but I'm not sure how it got here.
The way we're looking at it is that he is simply appealing the zoning administrator's decision to grant the variance to move the fence. As far as property lines go and anything like that, I would have to refer to Mr. Cox for that.
So the owner of 1704 Gray Street applied
Back when this
to move the fence?
started as a fence variation,
Why was it a fence variation? Because 1704 Gray Street was trying to build a fence?
the owner at the time of 1704 Gray, which was Brinshaw Construction, they applied to have the fence moved because it was a legal non-conforming fence since it was located in the front yard. They could not do anything to it without obtaining a fence variance.
Okay.
So they applied for it. By now, since it's gotten to here, the property has been turned over to the new owner,
Okay.
who is residing there now and simply does not care one way or another and wants to stay out of this.
So the current fence is at the lot line. The current owner.
No, the current fence is over the lot line by
About 3
4
feet.
feet.
about 3 feet.
4 feet.
So this fence, picture exhibit
A. Look at the next picture, it becomes clearer.
So the current owner has no plans to make any changes. The reason that we're here is because technically speaking, the current owner has your approval to move the fence.
Correct.
Okay. Okay.
Excuse me.
Yes.
The current owner, when he moved, obviously he was told about the fence, and he told me, I don't know his last name, but his first name is Chris. He told me personally that he doesn't care one way or the other.
Okay.
That may be true, but he's not here, and I just sort of point out
No,
that
I'm
that's
just-
hearsay.
I'm-
Although I think the fact that he's not here speaks volumes about how much he cares.
Agreed. All right. So now I'm going to turn to Mr. Cox, who is hopefully going to refresh my memory regarding the point Mr. Webley is making regarding his assumed rights because of the amount of time that he has been using the property.
For the record, Ken Cox from the city's law department. There are a number of issues that get confused in this particular analysis. The primary issue, though, is that Mr. Webley and his former neighbor, whose name I don't recall, Mr. Jones, they apparently had some sort of verbal agreement to share access to this particular piece of what, according to all records, was property that belonged to Mr. Jones, the previous neighbor.
Right.
Mr. Jones then sold his house in 2005. The property went into foreclosure. The bank took the property through a foreclosure action. And in 2010, the bank transferred the property to the developer Brinshaw NSP. And then earlier this year, Brinshaw NSP sold to Mr. Webley's new neighbor, the Meekses. The issue is that, again, I mentioned before, is about the recording. The agreement was entirely verbal, and nothing was recorded with the
So
recorded
no one
piece.
in title along the way of all these transactions flagged this issue.
That's correct. And
Okay.
and given that there was nothing recorded, there would have been no way for them to, it would not appear on a title search.
Right.
It would not have been something that they would have taken with notice of.
However, there is law regarding continued and consistent use of property which is not one's own as well, if I recall correctly, is there not?
There is, but that is not something which the Zoning Board of Appeals is empowered to decide one way or the
No,
other.
I know we're not empowered to decide that. I'm trying to even understand the framework of what,
Are we speaking of adverse possession? Is that what we're kind of skirting about here?
pretty much.
Yes.
Can I pose a question to you? I know we're not
Please.
deciding that, but to my understanding, I know he had permission, doesn't it? One of the determining factors for adverse possession is you have to have exclusive use of the property, which I thought the letter said that they both shoveled and maintained the property. And I think it also was determined on that you had to do it hostily. And it sounded
Right.
like, I think he had said that he had permission.
If it's done with permission, it's not adverse. Therefore, one cannot
So he-
adversely possess a piece of property with permission.
So you might have met the 20-year time frame, but not some other criteria?
Yes.
Okay, thank you.
Can I ask a clarifying question? I'm not sure who I'm asking it of, maybe Mr. Webley. Yes. Am I correct in understanding, just to re-parse the testimony, the Meekses don't plan to move the fence, as far as you understand?
Correct.
And you're comfortable with the fence where it currently sits?
Yes, I am.
And so the reason we're here tonight is because you're appealing a decision in the event that someone else decides to move the fence.
Exactly.
I would suggest a proposed solution, perhaps with us tabling this until another meeting. But if your neighbors are amenable to it, you could ask them to grant you an easement to keep the fence where it is, which would establish your right to have the fence there. We could come back and dismiss this appeal as moot at some point if your neighbors are amenable to the agreement.
Okay.
I'm just throwing it out. Does that
That
make
sounds so
sense?
logical.
Yeah, I guess sort of. I don't know how much you've kind of gotten into this with any legal staff or anything, but basically, and where I was trying to get with my questions to Mr. Cox is just trying to understand pretty much whether or not we even had the basis to be making it. Just like, do we? if it's general opinion that it would be considered in another forum to be Mr. Webley's right, then at a certain point we don't have the basis to make the decision about it. So I was just trying to understand a little bit, but
I think the only thing we have the basis to do, Lori, is to say whether or
No,
not the
and-
zoning administrator got it right to grant.
yeah, and but what Scott was trying to get at was that the most kind of permanent and safest solution in terms of what you're looking for, we think, is for you to ideally get a formal easement from your neighbor for the fence to remain and for you to have access to use that sidewalk. That's not something that we have any control over, but that's
I
something that we would
understand.
certainly encourage you to pursue if you're interested in that.
I understand, and I really don't care if they want to give me access
Okay.
to the sidewalk. What I care about is my part of the lawn, which I fenced off, and it has been there for 22 years, and it's not been based on adverse possession because it was open and notorious.
But that's outside of what we can decide here is the issue, I think. And so the best solution is for you to get some sort of written agreement for an easement with your new neighbor, the Meekses, and record it. And then the relief that the zoning administrator granted for the fence variation is sort of moot as far as the zoning board is concerned. Because you'll have then recorded an easement to keep the fence where it is.
And I guess my concern, and maybe you can clarify for tonight or not, but if Mr. Webley were not going to pursue an easement with his neighbor and wanted us to make a decision on this matter specifically, I guess my hang-up would be I would feel like I would need to understand whose fence that really, is there legal standing for Mr. Webley for that to be his fence on that other property, and that it's therefore, and he has legal right to have it there, then to me it would seem like the zoning administrator does not have legal right to say it can be taken down or something. But if it's not legally, then there is a right to make that change. Am I making sense?
I understand your point. The issue, though, becomes a matter of, as I said before, the record. The zoning administrator made a determination as to the fence variation based upon the documentation provided. And the documentation provided last year when the fence variation was granted indicated that the fence was essentially in the wrong place and was given the opportunity to move it in order to correct that based upon the information available.
Right.
Mr. Webley is making claims and providing essentially some sort of new information to which the zoning administrator was not privy at the time she made the decision.
Understood.
The issue now is whether or not there is sufficient basis to establish that any rights, if any, as a matter of law, which I think at this point actually would require a judicial decision, or perhaps if there were to be an easement or some other court document, something certified by a court or recorded with a recorder of deeds that would then change, that could then give you cause to overrule the zoning administrator's decision under the circumstances.
Yeah, I guess I feel like at this point I don't necessarily have, I don't have enough basis to make a final determination on this because I don't understand enough about the technicalities of the law in this area to understand whose fence it is.
I think the only thing we could do, if we actually are going to rule on this, is look at the record available to the zoning administrator at the time, and then a determination by the board whether the zoning administrator, based on that record, made a mistake in granting the fence variation. We would have to rigidly apply that criteria. We aren't charged with making a decision about adverse possession or whether there was a nonverbal agreement.
But typically speaking, one of the points of these hearings is to potentially historically understand items, understand the case further at a depth which was not previously allowed to be understood. So to me, if that means continuing it to understand that better, or if that means that this isn't the right forum because we don't know who owns it, I don't like.
The appellant admits that the fence is not on his property.
But he's not giving up the fact that he's stating that it's his and he has right to have it there.
Right. Well, I would suggest that we postpone anything further on this matter and give the appellant a chance to work it out with his new neighbor in a way that may make moot our need to try to move forward.
Do you have an interest in doing that, sir?
No, I don't, but my problem is, what if the neighbor sells and that issue comes up again?
Right, so you should consult a real estate lawyer, but based on my vague recollection of this from law school many years ago, I think if you get your current neighbor who owns the property to grant you a right in the property, an easement that runs with the property, then if he sells the property, the easement remains yours, regardless of who owns the property. So if you can come to an agreement with the Meekses that you have an easement to use their property for your fence, then it doesn't matter if they sell the property, you'll still have the easement in the property, not with the owner. The easement is in the property, not with the owner.
That is the most permanent solution, because even, for instance, assuming for a second that we overturn the decision of the zoning administrator, that's only a temporary solution on your part, because all we've done is say, right now, based on these current conditions, nobody can do this. But it's not permanent whatsoever. It does not stop the next guy from coming in and asking to move it, or frankly, from just walking out there on some Monday morning and tearing it out. That doesn't, our action, if we overruled the zoning administrator, wouldn't prevent that, and we would have no recourse in this forum if that owner decided to just go tear that out. You would be talking about, court if you were upset about the fact that it was torn out by somebody at some point.
Let me just add for the record, sorry. Since I am currently a practicing lawyer, I'm not giving you legal advice in any way.
I understand.
Okay.
My wife is also a practicing attorney, so probably if this is postponed, I'll have her here the next time.
That would probably be helpful.
So based on what you're saying then, one of my recourses is to get consent from my neighbor to use the easement. And the easement, based on your concept, would have included my 3 feet of fence that is allegedly belonging to 1704 Gray.
Yes, potentially. There's a range of easements that could be made, like I said, an easement could be up to and including access to the sidewalk, but if that's not what you're really pushing for necessarily, yes, it could just be an easement for access for that area and an easement to have your fence there. I mean, that would be a very relatively commonplace thing.
My best advice would be to try to ask your neighbors whether they're amenable to it, and then to engage a real estate lawyer to help you draft the documents.
Okay. And once it's done, what do I do? I come back here?
Well, I mean, what I'd propose is that we postpone anything further on this and set it for a future date.
What we're proposing is that if you're interested in doing that, since it is the most permanent solution to your concerns,
I am.
that we just continue this meeting and you keep in touch with staff, and if you're able to come to a solution that works, then we will simply drop this matter and you won't necessarily have to come back if you're able to come to a solution that's permanent and works for you.
Okay.
Okay? All right.
Thank you very much.
Mr. Cox.
This is a procedural matter. If there isn't a date certain to which the hearing is being continued,
We're just going to have to keep on moving it along.
then
Why don't we just,
I mean, we can throw it out there. I
why don't
think
we just
that
put
we
it out in
should
June?
throw it out there a little ways to give the applicant some time to,
assume it's
Or
going to take them at
some
least 2
time
months to
to-
work it out, right?
yeah, at least a month or two to figure out if it's, well, let's start with a month, because if he goes to his neighbor next week and they say, heck no, then we're,
Oh,
you know what I
Yeah.
mean? Then we're still back here. So, is that fair? Yes. Okay. So,
I would suggest the April 17th meeting.
April 17th, thank you. Okay, so we have a recommendation to continue this to the date certain of April 17th, at which time we will get an update. And if the issue at that point, sir, is just that you are still working on it and you need a continuance, then you need not necessarily show up. Just make sure you're in contact with staff, and we can do a formal continuance at that point without you necessarily being here. Thank you very much. Okay, so do I have a motion then for what we've just discussed? Do you have anything else before that?
I have something after that.
Oh, okay. So
I move in the matter 12ZMJV-0009 that we continue the matter to the April 17th meeting without closing the record, to give the applicant a chance to discuss the matter with his neighbor.
second.
it's been moved and seconded. All those in favor, please say aye.
Aye.
Aye. The motion is carried and you've been continued, so good luck, sir, with talking to your neighbor. And Mr. Cox, discussion of the Rules Committee, April 2nd. Is that what we're here to talk about, or something else?
No, that's actually a matter for you all to discuss.
Okay.
So I will wait until the end with a communication.
All right.
Sounds ominous.
It's not a new communication. It's a reminder of a previous communication. So.
Okay. Okay, so Melissa, do you have anything further to say about, other than just to note for the record that there will be discussion of the ZBA rules with the Rules Committee, which I've learned does exist, on April 2nd, 2012.
Before that, listed on the agenda is election of Economic Development Committee liaison. I know there's been some discussion back and forth with emails, but we need a formal election of a liaison so that we all know what's going on.
Until further notice, I will be the liaison to Economic Development Committee. And Mr. Rogers and I will be attending the Rules Committee meeting.
As far as the Rules Committee goes, they typically look at all of the different committees of the city, and they just want to know what the functionality of them is, what it is you guys do, how you review things. I think so they can get a general overview of it and see if things might need to be changed in the future. So the ZBA is up for the April 2nd Rules committee meeting just to explain what it is the ZBA does. I don't know if you guys will have any suggestions or comments about things that you would like changed or different things you may want to handle, but that may be a time to bring it up.
Okay. Mr. Marino?
Thank you. If I could just add, often what the Rules Committee is looking for is the work plan of a board or commission for the next year. Your work plan is kind of
Seeing my
set by your
smirk.
functionality
Okay.
in terms of special uses, major variations, appeals,
Okay.
and perhaps a reference from an alderman from time to time. So that's a very different structured work plan, very structured work plan relative to another board or commission that has considerable discretion and is picking different issues each
Okay.
year to study or analyze or make recommendations about. So certainly what Melissa and I will do is prepare a brief document that will kind of outline what we just said, and then if you want to add anything to that, you can.
Okay, and you guys will send that to me in advance, so I'm not blind?
In the supplemental packet that I emailed to everybody, it does outline what the ZBA does according to the zoning ordinance, and it kind of goes through variances, special uses, et cetera. So start with the basis of that. If you guys want anything added, or if we can come up with anything else, we can definitely add it.
Okay. And I would like to just remind everyone that I believe it is is it next Wednesday already? Next Wednesday, March 14th, 2012 at 7 p.m. Do we know what room we're going to be in?
Do you know where that's at?
I would think it would be in council chambers.
You think it will be in
Yeah,
here?
yeah, I'm not
Okay.
aware of a conflict we have, but we'll be looking at that just to see
Okay.
if we can make the accommodation work in here.
Okay, so Wednesday, March 14th, 2012 at 7 p.m. At the Civic Center, certainly, and hopefully in chambers, we will be having a special meeting of the Zoning Board and the Plan Commission together to consider the plan development at 635 Chicago Avenue. And then, Mr. Cox, you had something further?
Yes, and this actually kind of ties into the City Council Rules Committee review. In their general review, they're reviewing all the boards and committees and commissions and various public bodies that we have. One of the issues that applies to all of those various bodies is the Open Meetings Act, as you're all aware. And late last year, I think it was in October or November, I mentioned that there have been recent amendments to the Open Meetings Act, one of which has to do with training for all members of public bodies, which includes this board.
I do vaguely recall that now that you
The Attorney General, the Attorney General's website has online training regarding the Open Meetings Act. All persons who are members of a public body prior to January 1 of this year have until the end of the year to complete the training and provide a copy of the certificate that you get from the website, print it off and provide it to staff. If you become a member of a public body after January 1 of this year, you have 90 days from the day you became a member. So I'm here in part to remind everyone.
Is there a link that we could get or something?
I can send it out to everybody.
Direct us to that. Okay.
Melissa will give you a more specific link. The general link for the Attorney General's website is illinoisattorneygeneral.gov.
Okay.
And it's fairly simple to find through the Ensuring Open and Honest Government webpage.
Okay.
Thank you.
Anything else from anyone?
Can I confirm that
Yeah, I was going
we
to
have
say.
a quorum?
I was going to say, can we check quorum really quickly for next week? Scott, I know you just said you have a conflict.
I won't be able to attend. I'll be out of town.
Clara,
I will be here. Yeah.
you will? Beth? Yeah, 14th. You will be. And Beth, I think you were
Out of town.
out of town.
I could be here.
Andrew, you'll be here. And I'll be here. So that's 4 here. And I think that Matt will be there as well. So that should give us 5. How are we expecting this? How many meetings do we have any expectation of how complicated this case is going to be?
Hopefully just one.
Okay. We'll see. All right. Anything else before we adjourn? Thanks, guys. We'll be adjourned.